So we are still in Rule 112 and we are done discussing Section 1, that is the definition of your PI, but the most important thing to remember is when is PI required. Section 2, who are the officers authorized to conduct PI? Recall your COMELEC, your Ombudsman, and PCGG. So in this video, we're going to discuss the procedure if a case requires a PI, and we are going to compare that to Section 8. What is the procedure if a case does not require PI or is not covered by the rule on summary procedure? And then let's proceed to Section 4, the resolution of the investigating prosecutor and its review. So let's now compare the procedure if a case requires PI and the procedure if a case does not require PI. But first, when is PI required? PI is required when the penalty is at least 4 years, 2 months, and 1 day. Kaya lahat ng kaso na ifa-file mo sa RTC, they went through preliminary investigation. Bakit? Because for that case to be filed in the RTC, the penalty must be 6 years and 1 day. How about in the MTC? In the MTC, you have to qualify kasi kung kahit nasa MTC siya, for it to require preliminary investigation, the penalty must be at least 4 years, 2 months, and 1 day. How about in this table? That is your opposite, because if the penalty is less than 4 years, 2 months, and 1 day, then PI is not required. And which court has the jurisdiction? It is the MTC. So if PI is required, then how are you going to initiate your criminal action? First is you have to file a complaint. Where are you going to file your complaint? Rule 110, Section 1 has the answer. You are going to file your complaint with the proper officer. This proper officer could be your prosecutor, could be the ombudsman if it involves public officers, or it could be with the COMELEC for election offenses. So by filing the complaint with the proper officer for the purpose of conducting the required preliminary investigation. What is the requirement of the law if you're going to file your complaint? The requirement under Section 3 of your Rule 112, that is your letter A, is your complaint should state the address of the respondent. This is very important because later on, if the investigating officer decides to issue a subpoena, then how can you issue a subpoena if you do not know the address of the respondent? And together with your complaint is if you have witnesses, their affidavits, and if you have other evidence to support your claim, then you should already attach that to your complaint. Like for example, you need to attach a barangay certificate, or you need to attach, if it's a claim for rape, then you need to attach the medical legal. So include that already in your complaint. The reason for that is you want to establish probable cause. So in your affidavits, the requirement of the law is that it must be subscribed and sworn to before any prosecutor or government official authorized to administer oath. Take note while notary public is written here, take note that notary public, you are allowed only to subscribe before the notary public only in the absence or unavailability of your prosecutor. So we have here a sample of your complaint affidavit. Take note of the caption, Republic of the Philippines, Department of Justice, National Prosecution Service, Office of the City Prosecutor. So if you're going to file that in Makati City, then you have to put it, the city where you are going to file it. And then you have your complainant, who is the offended party, and the respondent, kung sino yung nagnakaw, nag-rape, or sino yung pumatay. is still called respondent and not an accused because you are in the prosecutor's level. Wala ka pa sa court, hindi pa umaakyat. Your IS number or your investigation slip number, and for what crime, the crime of rape. So take note that the address of the respondent must be indicated, and you are going to subscribe this document before the city prosecutor. So we are done with the first step or the first procedure if a case requires a PI, that is the filing of the complaint. So we're now going to compare it to a case which does not require a PI. Again, when is PI not required? When the penalty is less than 4 years, 2 months, and 1 day, and MTC has jurisdiction. So what is the first step here if a case does not require a PI? Answer is it's the same. They are the same. First step is you are going to file your complaint. But question, where are you going to file your complaint? Answer can be found in your Rule 110, Section 1. You have two options actually. First option is you can file it with the Office of the Prosecutor, and the second is you can directly file it with the MTC. But take note that if you are in Metro Manila, you do not have that option because you have to file it only with the Office of the Prosecutor. What is the requirement of the law if you're going to file your complaint? The same actually with your cases which requires PI. Section 3 also of your Rule 112, letter A, should be complied. The complaint should state the address of the respondent, attach the affidavits of the witnesses, attach also the supporting documents. The reason is for you to establish probable cause, and you have to subscribe your affidavits before any prosecutor or government officials authorized to administer oath. Notary public, while they are allowed, they can only do so in the absence or unavailability of your prosecutor. So after the filing of the complaint, what will happen next? It will be raffled and it will be assigned to a specific prosecutor. And that specific prosecutor will act on the complaint. There will be an action of the investigating officer which could either be dismiss the complaint or issue a subpoena. Where did we get this? This is your letter B of your Section 3. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss the complaint if he finds no ground to continue with the investigation, or he can choose to issue a subpoena to the respondent. And when this is his choice, issue a subpoena. Together with that subpoena is a copy of the complaint as well as the supporting affidavits and documents. Recall your subpoena, that is your Rule 21. This is your civil procedure. What is a subpoena? That is a process directed to a person, requiring that person to attend and to testify at any investigation conducted by competent authority. In this case, the investigation is the preliminary investigation conducted by the prosecutor. So let's now compare this to this table, a case which does not require a PI. So if a case does not require a PI, you can file your complaint either with the Office of the Prosecutor or directly file it with the MTC. But if you are in Metro Manila, you have no choice except to file it with the Office of the Prosecutor. So let us just say that this is the course of action. You filed your complaint with the Office of the Prosecutor. What is the next step, or what is the next procedure? Is it the same? The investigating officer will dismiss or will issue a subpoena? Answer is no, because here, if a case does not require a PI, the prosecutor shall act immediately on the complaint, either dismiss or prepare the information. Where did we get this? if you're going to read your Section 8, Rule 112, if the complaint is filed directly with the prosecutor involving an offense punishable by imprisonment of less than 4 years, 2 months, and 1 day, the procedure that is outlined in Section 3A of this rule shall be observed. But the prosecutor shall act on the complaint based on the affidavits and other supporting documents submitted by the complainant within 10 days from its filing. So you will now see the difference here, that investigating officer can issue a subpoena, but here in a case which does not require a PI, immediately the prosecutor can prepare the information. But how about if the complaint was filed with the MTC? It was directly filed with the MTC. Then what is the next step? The judge has 3 options: either dismiss the case or require the submission of additional evidence, or he can issue a warrant of arrest, or if warrant of arrest is too strong, just issue summons or a commitment order. So when is there dismissal of the case? If the judge finds no probable cause, then he can dismiss the case. But he can dismiss the case only after personally evaluating the evidence. Or if he cannot personally evaluate the evidence, or after personally examining in writing and under oath the complainant and his witnesses in the form of searching questions and answers. Take note, the judge can also require the submission of additional evidence within 10 days from notice to determine further the existence of probable cause. If the judge still finds no probable cause despite the additional evidence, then he can dismiss the case. How about the warrant of arrest? If there is a probable cause, or when the judge finds probable cause, then he can issue a warrant of arrest. But however, if the judge is satisfied that there is no necessity for placing the accused under custody, instead of a warrant of arrest, he can issue summons. Commitment order, when can it be issued? If the accused had already been arrested. So based on these 2 tables, we can say that if a case does not require API, mabilis na ang procedure, because if it was first filed in the prosecutor and the prosecutor prepared an information, then ang next step na niyan is aakyat sa court. The court will issue now a warrant of arrest, then it will schedule an arraignment, then pre-trial, trial, and judgment. And if it was directly filed with the judge, or with the MTC rather, then if there is a probable cause, the judge will issue a warrant of arrest, then schedule the arraignment of the accused, pre-trial, trial, and judgment. If you're going to compare that in a case which does not require, which requires a PI rather, after the action of the investigating officer, let us just say that his action is to issue a subpoena, ang next step niyan is the filing of the respondent's counter affidavit. This filing of the respondent's counter affidavit, take note that this is not available in a case which does not require a PI. In a case which does not require a PI, you do not require, or you do not give the respondent an opportunity to submit his counter affidavit. So let's explain number 3, the filing of the respondent's counter affidavit. Take note that this is not the case all the time, because it could be a situation wherein your respondent will submit his counter affidavit, or your respondent will not submit his counter affidavit. So if the respondent does not submit counter affidavit, what will happen? Will it dismiss the case? Will the case be dismissed because the respondent did not submit his counter affidavit? Answer is definitely no. Because if the respondent, ilang beses ko na yan inulit, if the respondent will not submit his counter affidavit, still your investigating officer or your investigating fiscal will still resolve the complaint. And what would be the basis of his resolution? That is based on the evidence presented by the complainant. That would be based on the evidence presented by the complainant. What if the respondent would say, ay, file na lang ako ng motion to dismiss because there is a basis to dismiss that case. Can he do that? Answer is no. Motion to dismiss is not allowed. If you're going to read the rules, the respondent shall not be allowed to file a motion to dismiss in lieu of a counter affidavit. So your only recourse is to file your counter affidavit, and your counter affidavit should include already the affidavits of your witnesses and other supporting documents. For example, wala ka naman palang utang, bayad na yan, o di kaya nagkaroon na kayo ng areglo, so meron ka ng compromise agreement, then you can attach that one. And the same rule also when we talked about the complaint, it must be subscribed and sworn to before the prosecutors. Take note again of the rule pagdating sa notary publics. They are allowed only if the prosecutors are unavailable or they are absent. And copies must be furnished by him to the complainant. So after the filing of the respondent's counter affidavit, what will happen next? There will be a clarificatory hearing. But take note that this is optional. This is optional. And we are talking about the procedure in a case which requires preliminary investigation. Because if you're going to compare it in a case which does not require a preliminary investigation, then hanggang number 2 lang tayo. Only 2 steps. Number 1, number 2. Tapos ka na dito. Ang main difference talaga nilang dalawa is if a case requires PI, then the respondent has that opportunity to explain himself, to submit affidavits, documents, because he is given the chance to submit counter affidavit. While here, in a case which does not require a PI, if you're going to read your Section 8, only Section 3, letter A, shall be observed, and that is the procedure. So what happens during the clarificatory hearing? Do not expect that this is a formal type of hearing, yung nangyayari sa court na nagkakaroon ng direct examination, isasalang, i-cross, i-redirect, i-recross. That is not the case in your preliminary investigation. Although parties are allowed to be present, but they do not have the right to examine or cross-examine. What you are going to do is just put your questions in a piece of paper, and then you submit that to the prosecutor, to the investigating officer, and then he will be the one to ask that question. Again, your clarificatory hearing is an optional. The word used by the law is may set a hearing only if there are issues and facts to be clarified from a party or a witness. So from number 1 to number 4, tapos na ang preliminary investigation, because the next step is the investigating officer will now resolve the case, and his resolution could either be dismiss the case or hold the respondent for trial, and in that case, he should prepare the information to be filed in the court. Section 3 of your Rule 112, letter F, is very clear that after the investigation, that is from your number 1 up to number 4, the investigating officer should now make a decision, and his decision is either to hold the respondent for trial or recommend the dismissal of the complaint. So if this is his choice, hold the respondent for trial, what is he going to do next? He should prepare the resolution and information. That information is the one to be filed in the court. And if he prepares the information, that means that he is certifying under oath that he has personally examined the complainant, who is your offended party, and the witnesses, that there is a reasonable ground to believe that a crime has been committed and that the accused is probably guilty of that crime, that the accused was informed of the complaint, he was also informed of the evidence submitted against him, and he is given that opportunity to submit controverting evidence. Take note ha, ang requirement lamang ng batas is to inform the accused of the complaint, to inform him of the evidence, and to give him that opportunity. It is not the requirement of the law that for the accused or for the respondent to submit his counter affidavit. Kaya kung yung choice ng respondent is hindi mag-submit, hindi mangialam, then that is his choice. The law respects that, but of course, it will not prevent the fiscal to hold the respondent for trial. Take note ha, that this decision of the investigating prosecutor or the fiscal, whether it is for dismissal or holding the respondent for trial, take note that this will be reviewed. This will be reviewed. Sino ang magre-review niyan? Of course, the boss, the big boss of the investigating officer. If you're going to read your section 4 of your Rule 112, very clear kahit sa title pa lang, resolution of the investigating prosecutor and its review, the review of the resolution of the investigating prosecutor. So no complaint or information may be filed, or no complaint or information may be dismissed by an investigating prosecutor without the prior written authority or without the prior written approval of the provincial or city prosecutor or the chief state prosecutor or the ombudsman or his deputy. But what happens in a situation wherein the case was dismissed by the investigating prosecutor according to the assistant city prosecutor, i-dismiss na yan. But sabi ng kanyang boss nung ni-review is hindi, mag-file ng information because there is a probable cause. Now, who will file that information? According to your section 4, the boss can file the information against the respondent, or he can direct another assistant prosecutor or state prosecutor to do so without conducting another PI. So take note that the decision of the investigating officer is not yet a final decision because it will be reviewed by his big boss, at dalawa lang naman yan. Either the big boss will affirm the decision of the investigating officer or he will reverse the decision of the investigating officer. So either in both cases, kahit sino merong malulungkot at meron magiging masaya. Kung ang decision is dismiss the case, then masaya si respondent, malungkot si complainant or si offended party, just like what happened in the case of Miss Denise Cornejo. Kung yan naman ay hold the respondent for trial, then masaya si complainant, malungkot si akusado. So, in both of these cases or both of these scenarios that we discussed, take note that meron pang remedyo. And what is that remedy? You can file a motion for reconsideration or sometimes called a motion for reinvestigation. Take note that you can do this only one time, and you can also directly appeal with the office of the secretary. So let's discuss this remedy, appeal with the SOJ. If you're going to read your Department Circular number 70, that is the 2000 NPS Rule on Appeal, the 2000 National Prosecution Service Rule on Appeal. Makikita nyo to sa website ng DOJ. Pwede nyo rin yan i-search sa Google. So What is the requirement? How are you going to appeal? Where are you going to appeal? Section 2 is very clear that you can bring your appeal to the Secretary of Justice. And what are you going to file? You are going to file a verified petition for review with the Office of the Secretary, Department of Justice. When are you going to do that? What is the period? The period is 15 days from the receipt of the resolution. But if you opted to file first a motion for recon, nag-file ka muna ng motion for recon or sometimes called a motion for reinvestigation, then you have to wait for the decision of this motion for reconsideration, and then if there is now a decision and it was denied, then you can file within 15 days from the denial of the motion for recon or from the denial of the motion for reinvestigation if one has been filed. Take note again, sinabi ko na to, only one motion for recon shall be allowed. So if you have an appeal with the Secretary of Justice, what is the effect? Section 9 has the answer. It will not hold the filing of the corresponding information in court. So magtutuloy-tuloy pa rin ang pag-akyat ng kaso sa korte. So information will now be filed in the court. But of course, this is only the general rule because if you're going to read Section 9, the first sentence, unless the Secretary of Justice directs otherwise. Kaya, if you're going to read further Section 9, look out ni appellant and the trial prosecutor to see to it that pending resolution of the appeal, the proceedings in court are held in abeyance. If you have an appeal with the Secretary of Justice, make sure that kung yung case umakyat na, information was already filed in the court, nasa MTC na or sa RTC, make sure that you are going to file a motion to defer the proceedings in the MTC or in the RTC. Take note that this is also a requirement if you're going to read your Section 5. If an information has been filed in court, together with your petition for review is a copy of the motion to defer the proceedings. Pero ang kailangan yung bantayan if you have an appeal with the Secretary of Justice is the arraignment. Kailangan nyo tong bantayan. Bakit? Because you have to make sure that si accused will not be arraigned. Otherwise, useless ang appeal sa Secretary of Justice because very clear according to Section 7 that if an information has been filed in court, the petition shall not be given due course if the accused had already been arraigned. Again, your petition for review shall not be given due course if accused has or had already been arraigned. Kaya kailangan yung bantayan itong arraignment. On the other hand, if arraignment was made after the filing of the petition, take note, arraignment is nangyari after the filing of the petition, it will not bar the Secretary of Justice from exercising his power of review. So if you have an appeal with the Secretary of Justice, if you are the lawyer of the accused, that is your lookout. Your lookout is for the accused not to be arraigned. Because if you will be arraigned, that would be useless. Napaka-useless niyan. In fact, in your Section 11 of your Rule 116, the law is even allowing you to file a motion to suspend the arraignment. Suspension of the arraignment, what is your ground? Your ground is there is a pending petition for review filed with the Department of Justice or with the Office of the President. Just take note though that this suspension of the arraignment is good only for a period of 60 days. After 60 days, ano na ang mangyayari? Depende na yan kay judge. Either he will continue with the proceedings or he will defer the proceedings. So that is up to the court's choice. So discretion yan ni court.